members and University of Law students. I'm the current chairman of 2022 of the Chartered Accountant Australia, New Zealand, Hong Kong Overseas Regional Council. I myself previously led global risk and compliance function at a number of multinational companies, covering areas including today highly relevant topic of data privacy. A bit of introduction of our CA ANZ for a wide range of audience today. We actually have over 300 registration today, so this is going to be a very interesting event. Chartered Accountants Australia and New Zealand represents over 130,000 financial professionals, supporting them to make a difference to businesses, organizations, and communities in where we live and work. CAs are known as difference makers. With the depth and breadth of our expertise, we've helped to see the big picture and chart the best course of action. In Hong Kong, we host a number of virtual and in-person thought leadership, CPD, social and networking events, activities every month for our members. On behalf of the CA ANZ Hong Kong Council, I would like to acknowledge this joint initiative with the University of Law Hong Kong campus, a panel of expert speakers from international law firm Bird & Bird, in China has significantly changed and shaped, which has made it very important for all multinational corporations operating in the region and Hong Kong and China to understand really to the risk and implication of this. I'll quickly go through the rundown of today's webinar. So as I begin with the opening remarks, then I'll pass on to Savas Michael, the Program Director of University of Law Hong Kong campus, to cover the background of this webinar and also the introduction of panel speakers today. We'll then move on to a Bird & Bird showcase, and then we'll have a presentation by the panel speaker of Bird & Bird, and then we'll finish off with a Q&A session and a round up by both of us. Thank you. So now pass on to Savas Michael, the Program Director of the University of Law's Hong Kong campus. Thank you.
Thank you very much, Andrew, and thanks very much to everyone for coming along today. Just going to move through the slides a little bit. So it's great to meet you all. Thanks very much for coming along to the talk, as Andrew said, on the PRC, Personal Information Protection Law and Data Security Law. The first, of course, piece of comprehensive and dedicated personal information protection law in China. So this talk will, as Andrew said, analyse the implications of this law and also the impact that it has on businesses. The University of Law Hong Kong campus and the Chartered Accountants Australia and New Zealand CANZ are delighted, of course, as Andrew said, to bring together this expert panel from Bird & Bird, as Andrew said, who I'll introduce in a moment, and will be our speakers today. So my name is Savas Michael, the Program Director at the University of Law Hong Kong campus. My background is predominantly in European Union law, and prior to joining the University of Law, I worked in the legal team of the Bank of England, predominantly working on matters relating to the General Data Protection Regulation, or as you know it, the GDPR, which is of course a regulation on data privacy and protection in the EU, but is not solely an EU matter. It has global reach and obligations that affect international and national companies, customers, and employees. I'd also like to introduce you to Kim Lee, who is Director of Partnership Development at the University of Law Hong Kong campus. Please do feel free to contact either of us if you have any questions, and our contact details can be found on this slide. Kim will be keeping a keen eye on questions which are raised during this talk, and we have allowed time at the end of the talk for these questions. So please do ask your questions within the Q&A box and we'll address them at the end. So I just want to give you a little bit of background information on the University of Law. I'm not going to read you through our full history as per this slide, but we are one of the UK's longest established specialist providers of legal education. Many of you may have heard of us as the College of Law, which we were known as until 2012, when we rebranded as the University of Law. In fact, Clarice, you, who's one of the Bird and Bird speakers today, is a University of Law alumnus from our London campus and also a mentor for our current students in Hong Kong. Oh, apologies. So whilst we originally focused on providing courses for qualifying solicitors and barristers, we now also have many courses which are focused on upskilling professionals in other fields. As you can see from this slide, we have plenty of postgraduate programs, including on data privacy, the LLM in data protection and IP, compliance regulation, and corporate governance. In fact, our corporate governance grad CG LLM includes modules on risk management and financial accounting and is accredited by the Chartered Governance Institute UK and Ireland CGI and leads to the membership of the CGI. We also run many shorter programs such as on legal technology and cybersecurity, as you can see there, with modules on AI and blockchain and the Internet of Things, for example, which will be relevant for the purposes of today's talk. Oh, apologies. So these are just a few bit of information of some of the kind of programs that we offer in Hong Kong. These are available face-to-face, but also online on both a full-time and part-time basis. And I've just included some links on this slide if you want to find out more about these programs or the Hong Kong campus, and as well as an email address to contact if you'd like. And of course, these slides will be potentially available to you afterwards if you wish. So please do contact us if you have any queries, and please do relate to these links. So as I said, this session is being delivered by our expert panel from Bird and Bird, and data privacy and protection is certainly an area we are interested in at University of Law. And we are fortunate enough to have 3 lawyers from the university, from Bird and Bird, sorry, oh, slides are changing, who will deliver this webinar today. So I'm going to introduce them briefly now. Mr. James Gong is a partner in Bird and Bird's Beijing office, focusing on clients in the technology and communication space. He has extensive experience in advising on cross-border mergers and acquisitions and general corporate and foreign direct investment issues. He has represented clients in a broad range of industries and specialized in technology, media, telecommunications, cybersecurity, and data protection. Ms. Clarice Yu is a general counsel in Bird and Bird's commercial team in Hong Kong and head of data protection group for China and Hong Kong. She is an experienced telecoms, media and technology lawyer with substantial data protection practice. Clarice has close to 20 years of experience advising clients on corporate, commercial and regulatory matters in the TMT sector, leading regional and international telecoms operators, media companies, multinational technology companies, payments companies, and institutional investors. Clarice is a frequent contributor to articles and publications on the evolving data protection regime in the region, in particular China's cybersecurity law. Ms. Amanda G is a senior managing associate in Bird and Bird's Beijing office with specializations in technology, media communication, dealing with regulatory regimes in TMC industries such as e-commerce, cloud, the Internet of Things, and artificial intelligence, providing legal policy and advisory on telecommunication, licensing, cybersecurity, privacy, and data protection matters for MSCs and domestic organizations. Amanda holds a Juris Doctor, JD from the University of Pittsburgh, a Bachelor of Law from Remini University, and admitted in the PRC bar, and is also a qualified US lawyer in Pennsylvania. So we're very happy to have our 3 speakers from Bird and Bird, a 3 expert panel along with us, and we're very happy to be co-hosting this along with the Chartered Accountants Australia and New Zealand. So I'll pass over now to James Gong, who's going to kick us off.
Yes, thanks very much, Savis, for your kind introduction, and also a big thank you to everybody who takes your time to attend this webinar, and we are hoping that we can bring you a good presentation of the key issues of the Chinese data protection laws, and we'll of course welcome any questions that you might have. And to to make this and to begin our presentation, I would like to just to bring our attention to the recent cases where Didi, the biggest ride-sharing company in China, has been under cybersecurity review since last July, and it seems that the investigation is still going on. We have also heard about talks of Didi being delisted from the US and perhaps relisted somewhere in China or in China mainland or Hong Kong. So the cybersecurity review is just one of these regimes under the Chinese cybersecurity and data protection laws that could have an impact on your business. And Didi apparently has borne the first round of this impact. And along with Didi includes two other companies who were listed in June in the US, and they were both investigated for cybersecurity review for allegedly putting large amount of personal information at risk of being at risk of harming national security. So this is a region that could really hurt your business. Take Didi for instance, if since last June it has been ordered to stop taking new users, and also its application has been taken off shelf in all the app stores in China, and this is a huge blow to the business expansion, considering that in fact its market share has shrunk since it has been put on the investigation. So this is just an example, and during our today's presentation we'll show you the major aspects of data protection laws and let you know what you might need to bear in mind when you are dealing with anything related to data. And now we have at the beginning of the presentation, I would like to start with a poll of questions where we would like to give you a test of your knowledge of the new law, and also perhaps hope that you can take these questions along with you, so that you will know how this regime will be different from the other major data protection regimes in China. So not sure if you can see the questions now. Is the left poll on or not? Let me see here. Sorry. Just let me. Yes. Okay, I'm not sure if the poll is on.
Yeah, James, the poll's working.
Oh, the poll's working. Okay. All right, I cannot sort of find the poll button for some reason.
Yes. How about I read the results out? So the question is the legitimate interest a legal basis under Chinese PIPL? And there was an alarming 158 responses, saying 78% agree that it is a yes, and only 22%, so 44 respondents said no.
Okay, all right, good. Yes, and Okay, how about the, now we can, yeah, okay, that's good. Okay, thanks. All right. And now we can start with the second poll question. Yeah, is the poll on? Yeah. Yes, all right. And okay, what is the threshold amount of personal information in terms of the number of individuals for governmental data export security assessment to apply? So just to give you a bit of a background, so data being exported outside of China, if the export triggers certain thresholds, to be set by the government, then and the export will be subject to a governmental assessment, which means that you need to get a government approval before you can actually transfer the data outside of China. And in terms of the threshold, would it be 1 million individuals, 10,000 individuals, or 100,000 individuals? Make your choice.
So James, the polls are still coming in quite aggressively. Yeah. So a lot of people are putting in their votes.
Oh, okay, great.
Okay, I might give them 1 more second. So if you haven't cast your vote, do so now. It is a sure winner though, I must say. So here we go. I might share your results.
Okay, yeah. All right, thanks for making your choices. And shall we proceed to the next one? Yes, and is binding corporate rules a valid safeguard for data export? Then this is the second question for data export. And for binding corporate rules, and this is a valid safeguard for under the GDPR for companies to transfer their data outside of the EU. And the question is whether binding corporate rules will still be a valid safeguard for data export on the Chinese PIPL.
Just a few more minutes, some data coming in.
Yep.
We've got a quorum. Surprisingly, this is neck and neck.
Wow, very good. Good, and let's proceed to the last one. So, what is the upper limit of fines that can be imposed under the Chinese PIPL in terms of percentage of turnover? Would it be 3%, 4%, or 5%? And under the GDPR, I can tell you it is the 4% under the GDPR. So what will it be on the PIPL? Will it be lower, will it be the same, or will it be higher?
If only this was the races, James. I think people have done their studies. But here I go, sharing the results.
Okay, good. Yeah. Excellent. Okay, I guess this is all the questions, and I think perhaps for the first question, I think we still would like to ask, whether you think that question is, do you think the Chinese PIPL has any extraterritorial effect, meaning that even if you are located outside of China, the processing activities taking place outside of China, would it be possible for you still fall under the jurisdiction of the PIPL?
We'll have to ask this live now because, or towards the end, because once we've launched the polls, we can't clear it.
Okay.
Back to you, James.
All right, thanks. Okay. All right. We'll let you have the answers. I mean, I don't think that you perhaps can get all of them right, but if you do, we unfortunately we don't have a prize for you this time. But I think, but congratulations to those who got the answers right, because I think you have perhaps a better knowledge of the law. But for those who didn't manage to get all of them right, it's okay, because we'll let you have the answers shortly. Yes, let's proceed to the yeah, I think I sort of showed this page before you answer the questions. So this is so on this page we're going to give you an overview of the data protection law in China, and you see there are 3 pillars of the data protection framework, and from left to right we have the PRC cybersecurity law, which took effect in June 2017. It focuses on the cybersecurity and network protection network operators. And in the middle, we have the data security law, which took effect on the 1st of September 2021. So this is pretty much a new law. And on the right, we have the personal information protection law, the PIPL, which took effect on the 1st of November. And this is even newer than the data security law. And just by the date of the effectiveness, you can tell that the year 2021 is a crucial year for Chinese data protection. And you will see that the Chinese legislator has stepped up their regulatory efforts in the past 12 months. And we have seen the explosion of all the regulations, and this explosion of regulations is still going on. We are seeing new draft laws, new draft regulations coming out on a weekly basis. So this regime is still developing, but I would say that these 3 laws are the cornerstones of the regime, and it is very important that we master these key requirements in these 3 laws, and you'll be able to understand all the other regulations that are published under these laws. And you can see that in red, we highlight the penalties under the PIPL is the 5% of the annual turnover, or renminbi 15 million, or whichever is higher. We do not yet know whether the turnover will be the group turnover, will be the entity that processes the personal information, or will it just be the entities within China? But it is possible that the Chinese authority might follow the suit of the its European counterpart, and apply the 5% to the group annual turnover. So don't be surprised if that is the case. And to illustrate the relationship between the 3 laws, I think it's better that we use a diagram for illustration purposes. And on this page, on the left, you will see that we have we use this diagram to illustrate how these 3 laws interplay with each other. So for the CSL, you can tell from its name that it focuses on cybersecurity. So what is cybersecurity? It means that it concerns whatever IT infrastructure or IT systems or information systems that you may have in China. If you don't have any sort of servers, you don't have any network systems, you perhaps don't have to pay much attention to this. But I have to say that by network systems or by network, in that you have to have a very complicated system of computers or servers. It really communicate with each other will be considered a network under the CSL. So however small the network you might have in China, or even if the server is not actually operated, or the network is not operated by you, it is operated by a service provider for you, or it is perhaps based on hosted on cloud, or provided by some cloud service providers, it will still be considered your network. Or by legal definition, it is the owner, the operator, or the administrator of the network that will be responsible. So if you assume one of these three roles in relation to your network, then you'll be liable on the CSL. And at the core of at the center of the CSL is what we call the multi-level protection scheme. The name is a bit of a mouthful, but what it really means is that the government would like to divide all the network systems into different have. Yep. Oops. That's the glitch. Okay. Hello? Okay. Yes, we are back. At the top level, you have level 5, which is the most important ones. But most network systems are likely to fall under level 1 to level 3. And then we have to note that for level 2 to level 3, that you will have to go through a process of being certified for your particular level and rectify all the gaps that you might have in relation to the protection obligations associated with your particular level, and make sure that you have your information system evaluated. So this is a process. There's a process that is required for your network system if you fall under level 2 and above. And in terms of its relationship with DSL, and you can see that both CSL and DSL have security in its name, but DSL concerns more the security of the data. And in terms of the overlap, the DSL actually, the security of the data will, to a large extent, rely on the security of its system, right? So if you have data, then you are obligated to protect the system that hosts that data in order to make sure that the data is secure. But in addition to that, you have more obligations in addition to protecting the system. For instance, you have to do the trainings, you have to make sure that you give the proper authorization to the people who have the needs to access the data, and you do make sure that you comply with the filing requirement, etc. So there are extra layers of protection of data on the DSL. And more importantly, the DSL creates, in addition to personal information, 2 categories of data that are protected under China. And this is not something that you will see in other data protection regulations or regimes. And these 2 categories are the important data and the core data. So the important data is defined as something that if it is somehow distracted or leaked, or if it is in any way illegally used, it will harm the national security, the national economy, or the public interest. And in the important data, there is also another category, that is even more important than important data, that is called core data. And unfortunately, the DSL does not give much of a clue as to what would be considered core data. In fact, it doesn't even provide much details as to what we considered important data. So for important data, what it says is that the ministries will publish their own catalog of important data. But for core data, it doesn't even say who is going to publish a catalog of core data, how you will define or identify core data. But at least for important data, what we know is that ministries will publish their own regulations. So that is very well, that's quite ambiguous in terms of and very unhelpful, to be honest, for companies to identify this. And for important data and core data, these two new categories of data are put into sort of a wider regime called it's still a mouthful. It's called the sort of multi-level classified data protection regime. What it does is that it divides all the data into different levels. And what we have seen in the draft regulation is that the data will be divided into 3 levels. At the top, that is the core data, as we mentioned. At the middle, it is important data. And at the bottom, we have the ordinary data. So, and in terms of classified, basically, companies are required to divide the data also into different classes in accordance with its use. So there is some extra work for companies to do once the DSL is fully implemented. That means that there is another regime they have to comply with in addition to protection of personal information. And now we get to the PIPL. So for PIPL, you see that it also has an overlap with the DSL in the sense that if you have a large amount of personal information, it will still be considered. It could still be considered important data. So, so the DSL also protects a huge amount of important personal information. For instance, the current criteria could be 1 million individuals' personal information. Then, if you have you process over 1 million individuals' personal information or more, then you may be subject to both PIPL and DSL. But generally, PIPL concerns only the protection of personal information, the protection of the interests of individuals in their personal information. So this is to illustrate the relationship between the 3 laws. And on the right, we put the different types of data to show that how they interplay with each other. So the personal information has an overlap with the important data, and as for sensitive personal information, it's part of the personal information, but it is more sensitive in the sense that it might have a more harmful impact if it is leaked or if it is illegally used. And for core data, it is we consider it in the part of the important data, but it is more important. And we also have the good old state secret. But for state secret, it is not governed by the three key legislations we just mentioned, because it is protected by a different set of regulations. And usually you will not have the access or the pleasure to access the state secret, because this is only generated by a small number of organizations, and you cannot. I mean, not every company can generate state secret, and they are supposed to be clearly marked so that everyone knows that this is state secret. But if you do have possession or have access to the state secret, don't share it with anyone else, and you can report to the authority and keep it confidential, because for most people you will not be in the scope of persons who are authorized to access state secrets. And this is introduction of the relationship between the key concepts under the three laws, and also how the three laws interplay with each other. And now next we are moving to the PIPL to explain the law in more detail, and handing it over to Amanda, who will tell you more about the extraterritorial scope of the PIPL. And over to you, Amanda.
Thank you, James. So now we come to the PIPL topics. So as we mentioned at the beginning of the poll questions, the PIPL does have the extraterritorial effect. So for a foreign company or even a Chinese company who is processing any personal information outside of China in a foreign jurisdiction, so if the purpose of the processing is to provide products or services to the individuals located in China, or if the processing in the foreign jurisdictions involves the analysis or evaluation of the behaviors of the individuals located in China, then the extraterritorial of PIPL is triggered. So that means that the foreign processing will be subject to the PIPL requirements, and the processor, the company, will need to comply with the applicable PIPL requirements in all material respects. So what does that mean for a foreign company? So the first would be to identify like whether you have any processing activities that will trigger the extraterritorial effect. And if the answer is yes, then the company will need to first appoint a subsidiary or individual as the local representative to handle the data protection matters within China. And then second, that the foreign company will need to consider all the key regulatory regimes under the PIPL and take actions in due course. But of course, the PIPL also has the in-territory effect, meaning that if you process any personal information within the territory, no matter whether you are a foreign company, a Chinese company, whether the individuals involved are Chinese citizens or foreign citizens, then the PIPL will be applicable. So this is more straightforward compared with the GDPR, meaning that we do not need to have the complex establishment or within the context of the establishment tax as under the GDPR. So under the PIPL, as long as the processing activities occur within the territory, then the PIPL become applicable. So if we move to the next slide, here. Like under the other data protection laws in foreign countries, for example, GDPR, in order to process any personal information in China under the PIPL in a compliant way, the company must have a lawful basis or legal basis for the processing. So in this slide, we list all the available lawful basis under the PIPL. So of course, consent used to be the golden rule under the PIPL, still is a very important lawful basis now under the PIPL. But in addition to consent, we now have additional lawful basis available for the processing. For example, the HR management necessity. This is a very unique design under the PIPL, which allows a company to process personal information, in particular the employee's personal information, without their consent, if provided that the processing is based on the necessity to implement any internal HR management or human resource administration tasks. And all those processing are actually objectively required by the rules, internal HR management rules, for example, provided in your internal handbooks or in other internal HR management policies or procedures. So some people say that this HR management necessity lawful basis resolves the difficulty that PIPL does not have the legitimate interest as a lawful basis. As shown on this slide, the very handy or useful legitimate interest lawful basis under the GDPR is not available under the PIPL. So many processing activities that would be based on the legitimate interest will need to find another suitable lawful basis under the PIPL. So for the processing of internal employee data, the HR management necessity would be a very useful one. But for the others, for example, the individuals are not internal employees, then some processing activities that could be based on the legitimate interest will need to be based on the consent of the individuals in China under the PIPL. So I think this is also a main focus when we review any GDPR or foreign law basis privacy notices or statements under the PIPL. We need to revisit whether the original lawful basis identified actually still work under the Chinese law. So in case the processing must be based on the consent as the lawful basis, then the three elements to obtain a valid consent include the individuals must be fully informed, the consent must be freely given and ambiguous. So those three elements, I think, are very consistent with the ones under the GDPR. But in addition to that, we have a unique requirement, separate consent requirement under the PIPL. And so as shown on this slide, before engaging in a few particular types of processing under the PIPL, a separate consent must be obtained. So this separate means that the consent to this particular processing activity cannot be bundled with the consent to the other general processing of personal information. So for example, if you process, if you engage in the processing of sensitive personal information, and even if that processing is necessary for the performance of any contract between you and the individuals, then the separate consent requirement still be applicable, meaning that you still need to go back to the individuals and ask for a specific separate consent to the processing of their sensitive personal information. And the same logic applies when you try to export any personal information outside of China, or if you want to share the personal information with another data controller, or we call that personal information processor under the Chinese law. So this separate consent requirement really causes some difficulties when the companies try to design their consent mechanisms. For example, if you obtain consent where a pop-up window, this basically means that you at least need two different tick box, one for the consent to the general processing and the other for the consent that requires the separate consent, all those particular types of processing activity. And sometimes you even need more tick boxes, because ideally in order to satisfy this separate requirement, each triggering processing activity will need one separate tick box. So this actually bring the IT teams and also the data team and legal team together. They need to sit together to consider how to design the most suitable consent pop-up window or mechanism for their operation. And also, in order to fulfill the fully informed requirement to obtain a valid consent, all those items shown on this slide must be included in your privacy notice or privacy statement to the individuals. Those are the mandatory items. So in other words, if you do not share all this information with the individuals, the consent that you obtain may not be considered valid under the PIPL. And also, in addition to all these mandatory items, we also recommend to include in the privacy notice additional information with both your entrusted parties, i.e. the data processor as under the GDPR, and also the other separate personal information processors, meaning these other separate data controllers as under the GDPR concept. And also we often suggest to include a designated section discussing how you're going to export the personal information outside of China. So basically this means that even if you have a GDPR or other foreign law compliant privacy notice, when you want to use that in China, in the Chinese market to obtain, to inform Chinese individuals how their personal information will be processed, a second review under the PIPL will be required, because based on our observation, different data protection laws do have different mandatory items that a company will need to include in the policy or notice. And now, after the general introduction of the PIPL requirements, we are going to discuss the very exciting or hot topics, how the data localization and cross-border transfer requirements under the PIPL will impact your processing activities or business activities in China. So I will hand back to James to have a further discussion with you. So James, back to you. Hello, James?
Yes. Hello, hi.
Okay.
Thanks, Amanda. And yeah, I was on mute, sorry. And now we are getting to the very exciting topics of cross-border transfer data export, as we will call it. So this is perhaps where you will find most challenging, and at least that is our impression, having talked to a number of our clients, and this is the part that could have the most significant impact on your business, because I believe that for those who have a subsidiary in China, you might somehow have some data being transferred from China to your overseas affiliates, and if the data transfer, data export falls under any of the restrictions, then that means that your current IT setup, your current management structure, or your current operation arrangement will need to change. And my advice is that to you is that get to know the restrictions, get to know what what your data export activities are, and if necessary, bring it to the attention of your internal colleagues or your management, and make sure that they understand what the impact is. And let's start with the 3 laws. So on the CSL, it is pretty straightforward. What it says is that if you are a CIO, meaning that if you are a critical information infrastructure operator, then you will need to go through, you will need to first localize your personal data, personal information, important data collected and generated within China. And when you export, export the personal information or important data, you have to go through a governmental assessment. So you will see that under the CSL, this is restricted to the operators of critical information infrastructure. So far, we haven't seen a list of identified CIOs or their operators. So at this stage, we don't know who they are, but suffice to say that the CIIs can only be found in certain critical industries. For instance, the financial industry, the telecom industry, or in certain circumstances, the transport industry, the energy, power, etc., that will be considered critical to the national security or national economy. So, and if you are a CII operator, then you will be notified by your sectoral regulator that you are you operate a CII or a CII. So in that circumstances, if you have not been notified, and if you are not operating in one of these critical industries, perhaps you don't have to worry too much about the CSL data exports restrictions. And for data security law, the DSL, what it says is that, okay, it will follow the CSL requirements, meaning that the CI operators will still need to localize the personal information, important data, and submit any export applications to the government for their assessment. What it says about security, about non-CIOs in relation to important data is that it will be regulated by the rules to be published by the authorities. And we have seen the draft regulations concerning export of important data. And what it says is that if you export any important data, it doesn't matter if you are a CIO or if you are a if you have a large amount of important data. It doesn't matter the quantity of the important data. So long as you export personal information, so long as you export important data, then you will be subject to governmental assessment. It doesn't say whether you will at the same time localize the important data, but our interpretation is that before you export the important data, you will have to store it in China, because before you pass the governmental assessment, you are not permitted to export the important data, meaning that you have to store it in China. Whether you will still be required to localize the storage of the important data in China after you have got the governmental assessment is not clear. But I think that since you have to find a place to store this important data, perhaps you still need to consider localizing the important data, at least for the purposes of governmental assessment. And for the personal information protection law, what it says is that if you are not a CIO, then you have to decide whether your data processing activities meets any of the thresholds to be set by the government. And what are the thresholds? The thresholds are now set out in the draft regulation. And since it's a draft regulation, it's not finalized. But I think this will give you a sense of whether your processing activities will actually be caught by one of these thresholds. So if you process personal information of 1 million individuals or more, right? So it doesn't matter, how small the amount of personal information you might export outside of China. So long as you process a huge amount of personal information, then your exports will be subject to the the governmental assessment, and also you will have to localize the personal information. And for the personal information, and also if you in aggregate export personal information of 100,000 individuals or sensitive personal information of over 10,000 individuals, then you still need to submit your personal information to the government for its assessment. So for the questions, actually, you should, the answers should be, all the three. So 1 million, 100,000, and 10,000. But if you trigger one of the threshold, then you will need to go through the security assessment, and you will need to localize your personal information before and you must not transfer it until you get an approval. Yes. And in addition to these export restrictions, there are some general requirements before you, under the PIPL, if you are transferring personal information outside of China, and this includes a security assessment, and this includes a notification to the individuals, separate consent being obtained from the individuals, carrying out the PIPIA, and adopt necessary measures to ensure that the recipient will be able to satisfy the requirements under the PIPL in terms of data protection. And in terms of the routes that you can take in order to transfer the personal information, the PIPL gives you 3 routes. One is for the governmental security assessment organized by the CAC, as we mentioned, but this is only triggered if we meet one of the thresholds. And the 2 other routes, if you don't have to, or you are not required to go down the governmental assessment route, then you will you can opt for one of the other 2 safeguards in order to transfer the personal information outside of China. One is the so-called certification from accredited certification bodies, and the other is a standard contracts to be formulated by the CAC, which is similar to the SCC's, the standard contractual clauses that you have seen under the GDPR. And for these 2 routes, the certification regime is not established yet, so it's not available. Standard contract is to be formulated. It's not finalized. No draft has been released. So we're still waiting for some new development from the CAC. Yes, so that's for the, and this is a flow chart just to let you know, what the export process will look like. And for the approval, I have to say that if you need to go through the governmental assessment, you need to understand that the process could take up to 60 business days, or even more in practice. And the approval is only valid for 2 years. That means that you have to apply for new approval every 2 years. And if there's any material change to your proposed export, you have to apply for a new approval. So that is more, I would say, quite restrictive compared to data export regimes in other jurisdictions. But if that is the way that it is intended by the government, then we'll have to face it. In the interest of time, I'm not going into details of the export contract, and what I can say is, for the points to take away, our advice is that you should conduct a China-focused data mapping so that you understand what is going on in relation to data exports, so you know what is being exported and to what extent, what is the quantity and quality of the personal information or important data. And secondly, if you will be signing, we have already signed an intergroup data transfer agreement under the GDPR, or if you have signed data transfer agreement with other entities, be prepared to sign the standard contract to be published by the governments. Also, if you need to go through the governmental assessment and localization requirements, consider what your options are, especially if you have a huge number of personal information or important data that needs to be exported. And you have to consider whether you really want to go through the governmental assessment, or do you have any alternatives? Because if you have to localize all your personal information, and that will be that could mean a huge cost for IT infrastructures, reshuffle of the management structure, and etc. So that is more than you might think in terms of impact. So be prepared. And also, there are maybe specific industrial rules to be published by sectoral regulators, and that may also have an impact on your business. And this is that's all for cross-border data transfer. And next, I'm gonna hand it over to Clarice for the for the data sharing and also the other important aspects of the PIPL. Now over to you, Clara.
Thank you, James. So for the next 10 minutes or so, I will cover some of the more accountability parts of the PIPL. The first one relates to third parties. I think essentially the key point to understand is that the PIPL also has similar concepts under the GDPR, like data controller and data processor, but they call it differently. We call it personal information processor, which means a controller. And then for processor under the GDPR, it's called entrusted parties. So essentially the concepts are the same. The personal information processor is the entity that controls or determines the processing and purposes and means. And then the entrusted party is the party that is bound by the requirements of the PI processor. So all your processing will be in the instructions of the separate PI processor. And in the middle, there's a concept of joint PI processor, which is similar to joint controller concept. So the entities jointly determine the processing purposes and means. And for joint controllers or joint PI processors, then they are subject to joint liability, and data subjects can come to either of the joint PI processors to seek for data subject rights, to exercise their rights. So the key point to understand is when you deal with third parties, to clearly understand whether they are separate PI processors, or are they joint processors, or are they entrusted parties, because the PIPL contains specific obligations on the PI processor in relation to sharing of data with these third parties. And at the same time, entrusted party, if you are an entrusted party in China, you're also bound by the PIPL to comply with the requirements imposed on you by the other PI processes. Can it move to the next slide? Yeah, so the next slide I'm going to talk about very briefly is individual rights under the PIPL. You can see that a number of the individual rights are very similar to the GDPR. And I would not cover all of them, but just to highlight a couple of the differences with the GDPR. For example, in terms of information right, there is a right of the data subjects to get information on the processing activities of the data controller, right, the PI processor. But the level of detail required under the PIPL is slightly different from under the GDPR. One key example is the legal basis of processing. The GDPR requires data controllers to list out the legal basis of processing. In China, although there, as Amanda has explained, there are different legal bases of processing, but the privacy policy does not have to list all of them out. So this is one of the key differences. So in terms of reviewing privacy policies, what we usually do is review many of the company's GDPR compliant policies and adapt them for China purposes. Another distinct differences in relation to the data subject rights is that there are rights on portability, for example, or rights to restrict processing, right to deregister. These rights, however, are subject to specific requirements by the CAC. So even though on the face of it, there are some rights, these additional conditions and restrictions are still not yet published by the CAC. So we will have to see what those additional requirements are before data subjects are entitled to those rights. And another difference with the GDPR is under the PIPL, there is close relatives. For example, access rights, correction and deletion rights. So this is also something which should be aware of, particularly from an employment perspective, for example. So in terms of response times and mechanisms for exercising data subject rights, the PIPL does not set out specific requirements at the moment, but in a draft regulation on data network security, there is a reference that response have to be made within 15 days of the request. And this is much more onerous than a 30-day requirement. So we should note potentially there is a more tight timeline to meet the data subject requests. And if the PI processes are not able to meet this data subject request, then the individuals have right to go to sue the PI processes in court and obtain civil remedies. Then on the next slide, it's a bit slow. I'm going to cover is some of the data governance requirements. I won't cover all of them in the interest of time. I think I'll just highlight 2 points. The first one is PIPA, Personal Information Protection Impact Assessment, very similar to DPIAs in the GDPR. So essentially the requirements or circumstances of conducting PIAs under the PIPL is much wider than under the GDPR. So it will cover circumstances including the processing of sensitive information, transfer of personal information to any third parties, cross-border transfer of data. All of these require PIPAs to be conducted. Another point we often got asked is whether you need to appoint a DPO in China. The PIPL at the moment set out a very broad requirement that if you process personal information exceeding a certain threshold, then you are required to appoint a DPO. But what is exactly the threshold, the million-dollar question, is not yet published. And at the moment, we are looking at draft guidelines and measures and national standards for this figure. And at the moment, the figure is pointing to about 1 million individuals' personal information, because we are relying on the reference in the draft regulations on data network security. So we will have to see what the number actually is going to be. But it will be a large number of processing activities relating to a large number of individuals before you are triggering the DPO requirement. And turning to the next slide. Yeah, and then I'm going to very briefly cover a security breach notification, because in China, there's also a mandatory requirement to notify in case of security incidents. And I think the key question is how quickly you have to respond to notify, and to whom you need to notify. In terms of to whom you need to notify, the PIPL requires notification to be made to relevant authorities and to the affected individuals. It is just worthy to note that the relevant authorities is not limited to just the Data Protection Authority, potentially also to other regulators depending on your industry, and also to the Public Security Bureau, which is the police in China. And in terms of notification to affected individuals, there is an exemption under the PIPL. Potentially, you can take a view not to notify affected individuals if you think that appropriate actions have been taken to protect them, but this view can be overridden by the authorities, and they can subsequently require you to notify individuals, even though you think that appropriate actions have been taken. The response time is then also a very significant question, and everybody get asked this question. And the PIPL does not say the timing. And we're looking at the draft data security measures, as I mentioned earlier, and the draft network data security measure provide a response time of 3 working days. So let me turn to the next slide. 3 working days upon a data incident. And if you process sensitive information or important data of over 100,000 individuals, the response time is 8 hours. This is very aggressive, much more aggressive than under the GDPR 72 hours, which already is very onerous. So we were waiting for anticipation. We hope that, potentially it could be lessened or changed in some way, but potentially these are the timelines we're looking at for China. So, I wouldn't spend too much time on the legal liabilities, as James has introduced at the very beginning. There are in addition to financial penalties, potentially civil penalties and criminal liabilities, as well as individuals personally responsible could attract a personal liability as well. And then the next couple of slides is on the GDPR comparison, which I will not cover in detail. The slide is moving very slowly, but I think the data security law, I wouldn't spend a lot of time, just maybe 1 minute before we go to Q&A. As James has mentioned, the data security law really is the protection of important data and security of the data, not so much of personal data. So there are obligations if you process important data or if you process data in China, there are specific security-specific obligations. And in terms of foreigners who operate in outside of China, you should note that the data security law potentially have extraterritorial application, as Amanda has mentioned. And so if you process data that potentially threaten national security or public interest, the data security law potentially has an application. And it also has wide application on conducting of national security reviews if depending on the type of processing you conduct, even if it is outside of China. And one important point and final point I want to make is if you do needed to export data outside of China to meet foreign judicial bodies' requirements to make access to data, you are subject to a requirement to obtain prior approval from the authorities before you can export the data, very similar to PIPL requirements. So this is also a very onerous requirement that is applicable under the data security law. So I wouldn't go on to detail and note that the timing is already coming up. So if you have any questions, we are happy to respond to them. And I see that we do have some on the Q&A chat box.
Thank you.
So hand over to Kim.
Thank you, Clarice. Thank you to the Bird and Bird team. It seems that there are a lot of potential issues that each company across various sectors may face, and the need for specific sector solutions. Companies should start reviewing their privacy policies and related disclosure regarding data handling practices and checking the adequacy of their consents. So what can we do now? How about we pass over to a couple of our colleagues. Elizabeth, did you want to ask some of the questions? We've got quite a number of questions here.
Yeah, we have a very good responses for questions, but conscious of the time, I'm just going to pick one because there are a few inquiries of the similar context. It's asking about the jurisdictions coverage about this PIPL. It's whether it's covered in Hong Kong. So say, for example, if a cloud operator has customer with operations in China, so is it better to have a data center located in China or versus have a data center located in Hong Kong? And does it make a difference? So we want to address that.
Yeah, I'll do the honor. Actually, for service providers in Hong Kong, I think the issues that you might need to consider will include, firstly, although Hong Kong will not be directly affected by the PIPL or the CSL or the DSL, but one thing is that if your customers are actually located in China, then it means that if they use your services, then they will need to transfer all the data outside of China, and that means that that means that they might be subject to any restrictions that may be applicable to them on the PIPL, the DSL, or the CSL, and they perhaps will need to consider whether they want to localize their data processing activities in China instead of transferring all the data to overseas service provider in order to avoid any of these restrictions under the law. So that means that they might be looking for a local service provider. So that's one thing. The other is that perhaps you need to consider whether you will be it is possible that you could be subject to the extraterritorial effect. Although as a cloud service provider, you perhaps may not be directly subject to the PIPL's extraterritorial effect, because you yourself may not be processing the personal information for the purposes of providing services or products into China, or you'll be evaluating or analyzing the behaviors of the Chinese residents. But the thing is that if your customers, they might consider whether they will be subject to the extraterritorial effect. And because of that, they might move their services locally. So that's one of the possibilities. Doesn't mean that they will necessarily do so, because we have also seen a large amount of companies who just decided to continue operating outside of China. But that is one factor that you need to consider, and also whether you yourself will be processing this personal information for the purposes of providing your own services products into China. And if that is the case, then the PIPL will apply directly to you, and as a result, you have to comply with all the material requirements under the PIPL.
All right, thank you, James. Just conscious about the time, I don't think we can address the rest of the questions. We already take note of all the questions that you asked through the Q&A button, and we're going to just provide answers to individuals by email. That works for most people. So shall we pass on the time back to Kim and the rest of you for the closing?
Sure.
Thank you very
Elizabeth.
much.
I think I've got emails as well with questions from Florence and Kevin as well. So thank you both for sending in the emails. So on that note, could I thank colleagues from Bird and Bird for sharing insightful and crucial contents? Could I thank the CA ANZ for collaborating with the University of Law, providing this important webinar to support businesses in avoiding data protection breaches? Participants are welcome to contact Bird and Bird, and we've distributed their contact details in the chat group for further matters related to PIPL. Could I also welcome you to contact the University of Law if individuals wish to further upskill themselves with education such as the LLM, corporate governance, or any data protection or IP or cybersecurity masters. On that note, thank you again and have a safe and wonderful week.
Thanks very much.
Thank you all. See you. Have a good day.